Welcome to the Rational Egoist. I'm your host, Michael Leibowitz. Anybody who's ever had to deal with the civil court system knows that it's kind of a combination of going to the dentist and going to the DMV. Today, to unravel that for us, is a former Connecticut Superior Court Judge and a former member of the Connecticut General Assembly. He is also the author of Common Flaw, Needless Complexity in the Courts and 50 Ways to Reduce It. Judge Thomas Moukawsher, welcome to the Rational Egoist.
Thank you. Good morning to you.
Good morning. If I had to sum up your critique of the legal system in one sentence, I would say that it contains, or actually that it elevates form over substance. First of all, is that an accurate summation? And secondly, what does it mean?
Well, it is an accurate summary of what I'm thinking, and what it means is that going to court takes too long, costs too much, and doesn't produce generally satisfying results in many cases.
All right. So what should be the goal of the legal system, and how have we strayed from it?
Well, I think what's happened is cases have become the cases themselves instead about the human values that are at stake in a lawsuit and the human beings that are involved in the lawsuit. And what I'd like us to do is to stop focusing on ourselves and on the process, because cases become fights about the case, what happened in the case, who made what motion, and what is it, and was everything put in the correct form, instead of about saying, all right, we have this human value that says that you should fulfill your promises, let's say in a contract case. And well, were those promises fulfilled in this case? What are the impact on real human beings? In family court, you've got family problems to sort out. And what's the future going to look like for this family? As opposed to, did that other person turn over every document that I demanded? And since they didn't, let's punish them for not turning over the documents. It all becomes about that sort of stuff instead of being about these people and their problems. And that's the central focus of my concern.
I've had to file motions in courts myself, and I've had to read a lot of case law, and it's just overwhelming. I saw a meme on Facebook that really captured it for me. It had a picture of a law library with, all the volumes and everything else and commentary. And it said, ignorance of the law is no excuse. This is the law. Like who the hell knows all this stuff? And one of the things you talked about was how there's too many motions, too many pleadings in court that contain way too much useless information. And you gave a lot of examples of that. I'm not going to ask you to give them all, but just so the audience can kind of get a sense for it. What are some examples of, I guess, duplicative motions and just useless information that's contained in them?
Well, those are two separate topics, and they're both a problem. One is duplicative filings. In other words, when someone sues a person and that person simply wants to avoid responsibility, they can drag the case out by, first of all, filing a motion to dismiss, saying the court has no jurisdiction. You can make up a ground, or you can have a good ground, but you say the court can't hear it. It's the wrong court. You're in the wrong place. Then you say then you file another motion that says you're the wrong person to bring the case. Then you file another motion that says not only were you the wrong person to bring the case, but you haven't used the correct magic words in bringing the case. And so that's three right there. And then the final thing is you say that the case should be summarily thrown out of court on various grounds. Each of those motions can take a year or two to decide. And that's why litigation lasts as long as it does. And what I've done in court and what I propose in my book is that you say, I'll hear that type of thing once, and we're going to do it now, and file a 20-page brief, not a 400-page brief. And that leads me to the second thing in terms of what lawyers file and what judges write is filled with useless information. A typical brief or a typical judge's decision often starts by saying, something like, this action was commenced by a writ summons and complaint dated January 1st, 2022, and returnable to the Judicial District of New London at Norwich. Thereafter, one of the parties entered an appearance through attorney John Smith, and a motion for to dismiss was thereafter filed. You don't need any of those things to actually make what you're asking plain to the court, and the court doesn't need any of those things to make a decision. And yet this boilerplate is usually at the front of every decision and at the front of every brief, so that an ordinary reader sees and says, why am I reading this? Why am I reading this? What's this about? And early on, even as a law student, I realized that when you read a case, you have to flip, and there you find a little nugget at the back of the decision or at the back of a brief that, oh, that's what this is about. And if you can find the golden nugget, you can understand what's really going on, but you shouldn't have to search so hard.
No, and a lot of the information you wrote is stuff that everybody agrees to. So what is the point of having to state, the plaintiff's name is, for the record, it's Michael William Leibowitz, or, he works as a podcaster, but everybody agrees to that, but they fill these motions and pleadings with this information. Why?
Well, there are multiple reasons. One of it is simply inertia. In other words, that when lawyers get out of law school, they start to look at what other lawyers have written in the past. They want to be accepted as part of the legal profession. So, boy, this looks like a really legalistic document. I must have done a good job. It's in other words, you do it by imitating people. And judges are the same way. They look at old past opinions and say, well, I'm a new judge. I've got to be accepted as a judge. I should write like other judges do. So it carries on that way because people believe it's the correct thing to do. There are also incentives in the system that cause problems in that regard too. One of the incentives is in many types of litigation, the parties are billing by the hour. So you might assign a young lawyer to write a brief, and you want it to be a good one, and so you certainly don't mind that young lawyer spent more time on it than less time, because if it's billable, that's a good thing. This may be subconscious. I'm not trying to say people run around trying to rip people off, but a thorough job is also one that gets paid well. And then on the court side of it, I think that in some cases, we judges have misused our law clerks by giving them busy work to do, when what we should be doing is exploring the edges of the law and how to smooth them. Instead, we have our law clerks writing background like that. You start the opinion for me by putting all this background about the law, the facts, and that stuff. And so it just builds and builds and builds. And so to give them something to do, instead of giving them something meaningful to do, they do that sort of work. So
It's funny to me when you say how a lot of it's imitative, because I don't know if you've ever had the opportunity to read inmate pleadings when inmates file lawsuits, and it follows there too. I mean, you'll see stuff like, Mr. Leibowitz is a pro se litigant filing on behalf of Mr. Leibowitz in regards to the petition that for the offense that took place circa 19, whatever, and the motion in limine was filed, and they throw in all these extra Latin terms, and it's just ridiculous. Just speak English. Everybody here speaks English. So why all the Latin and all the, highfalutin language?
Well, so I think, a person who's trying to represent themselves in court would do very well to go back and consider their grammar in high school English. Start with that. In fact, I've always told lawyers and others that if you want to write something, almost no matter how long it is, you can start with 5 things. You have an introduction, you have 3 points you want to make, and you have a conclusion. And if you remember that from early on in life in school and put it all in plain English, you'll do pretty well, rather than trying to imitate what goes on in court. I had a person representing themselves came in front of me and modeled what they filed based upon a federal lawsuit they saw. So it was about 100 pages of indecipherable stuff. And so I said, just wipe it all out. Forget everything you said. Throw that into the trash and tell me who did what wrong to you. Talk about each person. This is John Smith. What did John Smith do wrong? Write it out in plain English. What did Susan do wrong to you? What is your claim about this person? And just write it to me in plain English. And that will be the complaint that gets filed. So we can all understand who you're claiming wronged you and why. And it turned into something that was 7 pages long. And it was quite easy to understand.
I've seen guys file, for instance, a habeas corpus petition saying that their detention in prison was unlawful for one reason or the other. And I've seen it get dismissed, not based on, the justice of the claim, but for something like you were supposed to include 7 pages of double-spaced sentences. Instead, you included 7 pages of single-spaced, sentences. And it's like you said, it's form over substance. Forget about the justice of whether the claim is accurate. It's not filed properly. And you mentioned that courts will often look for excuses to be able to get cases off the docket, to clear the docket. How common is that?
Too common. I would say that I think I'll just give you the example from the prisoner's context. There are many technicalities that can flaw a complaint that a prisoner might make. Usually it's a civil rights complaint. They're having cruel and unusual punishment inflicted on them. And we get those things all the time. And many times they get said, well, you didn't exhaust your remedies in the prison, so you're dismissed. Go back and exhaust your remedies in the prison. Or did you name the warden in his individual capacity or in his official capacity? And since you messed it up again, you're dismissed. And you do have to do those things correctly. But let's say you filed a complaint for something like, I think that I should have this $400 pillow that I found in a and if you don't give me the $400 pillow, you're inflicting cruel and unusual punishment on me. And I've had cases like this. And some judges would say, oh, well, you didn't exhaust your prison remedies, out you go. And I would, or you didn't sue the person in their correct capacity, out you go. I would say to a complaint like that, okay, you didn't exhaust your administrative remedies. All right, you didn't name the warden in the correct capacities. But even if you did, the Constitution does not entitle you to a $400
Right.
pillow. Out you go. You see, you're getting to the substance of it and not hanging yourself up with the technicalities, because then the prisoner thinks they just deprived me of my hearing. I didn't get heard on my actual claim. And you're better off saying, you know what, you don't have an actual claim. And
Right.
if you do, of course, you can get over these other hurdles if you've got an underlying claim that's got merit. But if there's no merit to it, why throw it out on a technicality? Throw it out on the merits.
It's funny you say that, because I remember getting aggravated with guys that would make frivolous claims like that. I wasn't given the proper pencil or whatever. You're just making ridiculous claims, because my thinking was that if courts are confronted with all this frivolous stuff, there's going to be a tendency to basically just dismiss offhand even stuff that has validity. And I wonder how much that actually takes place now that I've read your book, and where you talk about they're looking to clear dockets, even with frivolous lawsuits in the community, where courts are just inundated with this stuff, and they're just like, we got to get this out of here. Is that a common thing that occurs?
Well, frivolous claims are a genuine problem in court, and they do exactly what you say, which is that if you have 20 frivolous claims for every one meritorious claim, and that meritorious claim is like number 17, you're going to be suffering from fatigue, from frivolous fatigue. You're just going through. So when you start the next one, you start saying to yourself, here we go again. And so it takes an extra effort to focus on the one that has merit. It would be so much better if they weren't surrounded by so many frivolous claims. It certainly includes prisoner complaints, but it covers the waterfront in terms of family court, civil court, et cetera. You have these problems all the time. And that increasing numbers of people filing things they shouldn't really do hurt everybody else. And I also advocate not allowing the court system to be abused, and that there have to be consequences for people who lie in court. And
Sure.
and to deter this sort of thing. If they think they can, without consequence, barrage the courts with lies, then we're just going to get more lies.
You just mentioned a few minutes ago the exhausting of administrative remedies, right? That's a nightmare. But give an example, like if you're dealing with, say, the Department of Health and Human Services, and you've got an issue with them, what does it mean to have to exhaust your administrative remedies? And how does that get in the way of actual justice being served?
What it's supposed to mean is that if there's a judgment call that a department has to make, let's say it's a licensing question, you're a licensed therapist of some sort, and they take some action against you that you don't like. And it's based on their judgment. They say, for instance, you're an incompetent therapist, and therefore your license is revoked. In that situation, they're supposed to have an internal mechanism, a way for you to say, you've treated me unfairly. Review this. I appeal the original ruling, review this, and make a good, fair decision. And that's what a typical administrative remedy would be. So if you've gone back to them, asked them to reconsider, asked them to reverse their decision, and they won't do it, then you can go to court. But if you didn't ask them to review their initial decision, then the court would say, you didn't exhaust the administrative, you could have fixed this below, and we send it back. One problem with these cases is that sometimes the administrative agency says, this is what the statute means, and therefore your license is pulled. Well, that's not the administrative agency's job to say what the law is. Only the courts say what the law is. So in my view, I would not make the person who's complaining go back and ask them to change their position about what the law is. If it's a legal question, the courts should resolve. If it's a question of expertise, where you have a judgment call by, one set of doctors about another set of doctors, well, maybe you should give that set of doctors, a second chance to look at it, but not when it's about the law. And too many times, again, it's probably subconscious. It's just easy to say, well, let's send that back to the administrative agency to take another look at it. And this has been a controversy for many years about administrative remedies. And it's been pushed to absurdity under some circumstances, is that it's just, hey, go back there. I'm not the person to deal with it. You do it. It's a sort of Pontius Pilate routine.
Yeah, and then there's this idea that these agencies are investigating themselves, judging their own behavior. When Brent McCall and I, my former cellmate, we wrote Down the Rabbit Hole, How the Culture of Corrections Encourages Crime, there were correctional officers that tried to have me assaulted. I looked up the statute and I found reckless endangerment. And I wrote to the chief state's attorney and I told him, listen, these correctional officers, and I have witnesses, are trying to have me hurt. They're guilty of reckless endangerment. I want you to look into this. The district attorney wrote me back and said the Department of Correction will do its own investigation. And I remember thinking, well, Jesus, when I was arrested, I didn't get to investigate myself. You know what I mean? Somebody else did. It seems like that's a problem. Now, obviously, I have a personal bias in that case, but I'm just saying in general, if agencies are accused of wrongdoing and they're going to do an internal investigation, that seems problematic to me.
Well, yeah, I guess the reasoning would be to say that, all right, let's say it's a certain correction officer or more than one correction officer doing something, and the warden, let's say, has no idea that this is going on. And someone brings it to the warden's attention, and then the warden, if the warden's doing the job, goes back and deals with it. And so the argument is that, yeah, the warden should know about this. The warden should do something about it. But if the warden says, I've investigated it and it's all fine with me, the real issue is, should it end there? And that's where, the state's attorney might say, okay, they've completed their review of this and they've found no wrongdoing. Maybe now we should look at it. But their argument would be, in the first instance, let's assume we have a responsible and honest warden here. The responsible and honest warden should fix this problem, because in the first instance, it's their job to do it. But if they don't, and there's wrongdoing, well, then I would think that the state's attorney would have a basis to do something about it.
But in general, these agencies, and there's so many of them, right, in government, Is that typical where they would have to look into their own sort of bad behavior? And how common is it where courts afterward will actually look into it, or they'll just say, we accept the finding of the agency?
I use an example of that in my book, which involves pensions, and where the state board that deals with state employee pensions made the claim that even though there was a simple legal issue at the root of the issue, which should have gone to court immediately, in my opinion, knowing that courts would send it back to them, the case went to the agency and was studied by the agency. Well, the agency said, here's how we're going to study it. First, we're going to have a subcommittee, then we're going to have a committee, and then we're going to have an appeal to the committee, then we're going to have a review of the appeal of the committee, and then we're going to have the full committee look at it, and then we're going to have a hearing, and then we're going to have a review of the hearing results. And it was a process that took 5 years. So the very process of the agency reviewing itself and making these decisions was kind of a joke in that circumstance. It can be abused, it can be done honestly, but I've seen cases where it's not done correctly. And that's an instance. And what happened is when it went to court, it just didn't, it seemed too much for the court, I think, to untangle. And they just, in that instance that I write about in the book, they didn't untangle it. They just, case is too old. They said, well, it's too old. You say it's too old because it's been, and that happens. So it happens. And this is the kind of thing I'm trying to argue that we have to, as judges and lawyers, have to stop happening, because it undermines faith in our system. And I have a great deal of faith in our basic system. I think we have a basically honest system. I think that you've commented even that the people you encountered in prison were at least people who are trying to do the right thing. And I can assure you that judges are trying to do the right thing, but they make mistakes of form over substance that we need to weed out if we're going to build and renew the public trust in the system. And I think, if you look at how law works in other countries, you can thank God for what we have. There wouldn't be any appeal to the warden.
Yeah. That's true. As I'm reading your book, I was reminded of Charles Dickens' book Bleak House and the case John Dice versus John Dice, where this case went on, I forget how long, but a long time. And what happened was everybody became interested in the case continuing to go. Lawyers were getting paid, the judges getting paid. I don't remember exactly, but probably clerks are getting paid. And eventually they just exhausted all the funds that were involved in the controversy to pay legal fees. In our system, it seems that we have that same problem where there's so many people that have an interest in the system operating as it now does. How do we change that? How can we change the incentive structure so that the interest is in justice and not just maintaining the status quo?
Well, I think one of the major things that needs to be done is that the way attorneys charge for cases needs to be changed. If you're going to bill hours and then you're going to get paid by billing hours, and your incentive is to bill hours, whether you do it consciously or subconsciously, you're going to have more hours spent. So a model of aligning the client's interest with the attorneys is, let's say, in a personal injury case. In a personal injury case, the basic formula is that the lawyer takes, say, a third of whatever is recovered. What is the lawyer's incentive there? To recover as much money as fast as possible. So you want to go through the system very quickly. And if the other person on the other side and the defense on the other end is getting paid by the hour, well, they don't mind it goes on a long time, do they? So you need to take the person on the other side of that case and create an incentive for them to win the case as fast as possible. My suggestion is that there are flat minimum fee amounts for defending a case like that, and incentive bonuses. If you win the case early, you get this extra payment. If you win it soon enough, you get this extra payment, but you get a minimum flat sum as opposed to being paid by the hour. I have a few different ideas about that in the Common Flaw, but that's basically the idea, is to change the incentive so that both sides are perfectly aligned with their clients, and that's clients' best interest.
One of the solutions that are, what's the word I'm looking for here? Maybe strategies that you recommend for helping to fix the system is implementing technology, right? Letting juries serve remotely, that sort of thing. People in general, it seems, are hostile to new technologies. They don't want things to change. How can we get people to accept the idea that technology is a good thing and can be used to make the justice system better?
Well, an emergency helps, and that's what happened in COVID. So a lot of people who, if you sat them around the table in 2019 and said, why don't we do a remote hearing in this trial? Why don't we do a remote argument on this motion? They said, are you kidding me? We can't do a thing like that. And then COVID came along. And the next thing you know, you're trying our cases online. And not only did I do it during COVID, but I continued it after that. And it allowed me to help try cases in another part of the state far away from where I am, where they had an enormous backlog. And I could be in another courthouse far away doing exactly what we're doing, which is how I tried cases. And I've tried hundreds of cases now remotely. We've never experimented with the jury part of it yet, but I have a belief that it'll come to pass because people are getting used to doing what you and I are doing right now. And this was not so common before COVID either. Now it's just universal.
Yeah.
This is how we talk. So I think it's gonna happen.
You also talked about jury selection, and you think that judges should play a bigger part in it. And I actually thought it was a good idea because I don't think that when you're trying to get justice, whether criminal, civil, whatever, you ought to be looking for jurors that you can convince of your point of view, or jurors that you think are susceptible to your argument, where there's like even jury consultants who advise lawyers which jurors to select or which jurors not to select. The goal ought to be getting a just result. And that just doesn't seem to me that it actually serves justice. How do you think that having judges involved in the process would help to serve the interest of justice, to get the right result?
Well, first, the basic questions in those circumstances would get asked by the judge, not the lawyers. And lawyers have an incentive, of course, to try to indoctrinate the jurors and say, you'd ask a question like, my wonderful, poor, widowed client who spends her time knitting for the homeless shelter.
Yeah.
Really like to have a fair and impartial juror. Do you think you could be fair to this poor widowed lady who knits and you indoctrinate them, you're planting this stuff. And when a judge asks you to say, well, all right, have you ever been in a lawsuit? Yes or no? No, I've never been in a lawsuit. All right. Do you know any of the parties in the case? No, I don't know any of the parties in the case. Do you think that the American system of justice can produce a fair result? Yes, I do. And you ask questions like that as opposed to questions that have built-in conclusions and information. And then once you say that about the widow on your side of the case, the other side then has to say, well, my child, the orphan,
Yeah.
without shoes, would like to know.
Yeah.
So what happens is the time it takes to pick jurors in that sort of competitive, you're fighting over the soul of each potential juror, takes enormous amounts of time and really irritates the jurors too. So if you have the judge doing it, it'll be shorter and it'll be more neutral.
He also doesn't have the bias of trying to find the juror that's going to go one way or the other. I remember my lawyer telling me during it's voir dire. It's funny. I like when you mentioned in the book, like, why not just call it jury selection? Like, why do we have to call it voir dire? But there was an engineer that was in the jury pool, and my lawyer said, we want to get the engineer because engineers are hard. They want an abundance of evidence before they're convinced. They're very particular. And I thought, well, that's great. The engineer just ended up saying he couldn't serve, but it just always sticks in my mind. Like, you're looking for people that are going to give you the result that you want. And that just doesn't seem to me that should be the goal of the system. I understand it being the goal of the lawyer because the lawyer wants to win the case for the client, But the system as a whole, I don't think that should. I like your idea, I guess is what I'm trying to say.
I think it is a better approach, and also I think that lawyers overwork some of those angles, and that engineers are people too, and the idea that all engineers think alike or have certain kinds of prejudices, they're going to find many times that's wrong. And so I found actually that in cases, because I did a lot of work in federal court, and cases in federal court where the judge does preside over the jury, they get a jury very quickly, and you're usually surprised at how objective an engineer or anybody else it's being. I love the jury system. I think the jurors, when they get to actually deliberate, always do what they think is correct and fair, and don't act out of a bundle of prejudices. They have a lot of respect for jury service, and so do I.
One of the goals that you seem to be, well, not seem, that I know that you're trying to achieve, is to increase public trust in the legal system. First of all, do you think it can be done? I mean, I'm guessing yes, because otherwise you don't write the book. But how? In what ways would people come, or what would cause them to trust the system more?
Yeah, a system is a system of justice in part by being perceived as a system of justice. If it's not perceived as a system of justice, then it undermines its very existence as a system of justice, because justice is a thing that has to be felt to exist. And if people leave court and feel that they weren't dealt with fairly, even if it's the right result, you sent them back to the agency when you shouldn't have, but you figured, well, the case was going to lose anyway, so I got rid of it. That's not going to create a perception of justice. That's why I would say, in the situation where it says you didn't exhaust your remedies, and I'm going to send you back to do that, where the issue is something where you're going to lose anyway, say you don't have a case. So then you say, all right, somebody heard me and said I didn't have a case. A jury made a decision in the case, as opposed to getting thrown out on technicalities and emotions and things like that. And so the common flaw, the idea is that there are 50 things we can do to make a case go to a trial, to get heard on the substance of the case, and give people a result in plain English that they can understand. And I think doing that sort of thing can increase the public faith in a system they ought to have faith in, because it's a system that I'm pleased to say is a fundamentally honest system. And I think I pointed out in the book, but if you go to China, you go to Russia, they are fundamentally based on bribery. And if anybody thinks our system's based on that, they don't know what they're talking about, because it isn't. We have flaws, but we aren't a fundamentally wrong-headed system. We are not. And the judicial systems in most of the most populated countries in the world are thoroughly and systematically corrupted by bribery. And so we've got this wonderful thing that we need to build confidence in. And that's what these points are all about.
You mentioned plain, understandable language. Your book is written in plain, understandable language, and anybody interested in the topic of the legal system, I'd recommend the book. It's a good read. It's not difficult to grasp. Straightforward solutions. I thought it was a good book. Okay, Judge Moukawsher, have I forgotten anything? Have I not allowed you to get anything in? Is there anything else you'd like to say?
This has been very thorough and very thoughtful, and I really appreciate the opportunity to talk to you, because we're obviously prepared well. You know what you're talking about. This has been a very interesting discussion. So
Thank you.
thank you.
Okay, well, where can people find you, and where can they find your book?
So the common flaw, if you go on Amazon or the Brandeis University website, or just Google the common flaw, you'll find me and my book. And I have a website, thomasmoukawsher.com too.
Awesome. Thank you so much, Judge, for taking the time. You're actually the first judge I've had on. So that should be an honor for your honor. It's certainly an honor for me. Thank you so much. And for now, this is the Rational Egoist signing out. I'm Michael Leibowitz. Remember, let me know what you think. Till next time.